Legal terms. Part 4. Oath. It is an appeal to God to witness the truth of a statement. Any statement made after taking oath is believed to be true. Any statement made on oath will, if found to be false, be a ground for a proceeding against the person making it, for perjury. A Hindu takes oath on the Gita or the Thirukkural. A Christian takes oath on the Bible. A Jew takes oath on the Pentateuch, and a Muslim takes oath on the Quran. Obscene. It is also a relative term. What is obscene for one person may not be obscene to another person. It all depends on how a man thinks of it. In general, obscenity creates immoral influences which result in corrupting a man. Obscenity confined to an individual is not an offense. It is an offense only when the obscenity is published, distributed, sold, and printed so as to influence the mind of person in whose hands this is passed. Partition. Partition indicates the joint enjoyment and possession of a property by the sharers of it, and who have the right to divide the property into separate divisions. The sharers of the property may divide the property, each one taking a division in it, and thereafter having an individual title to that division. There is no conferment of any new title to the sharer. He acquires his individual title by virtue of partition. There is a change of status as well as division of property by natural agreement. Persona designata. A persona designata is a person who is pointed out or described as an individual filling a particular character. He is a person selected to act in his private capacity and not in his capacity as a judge. This expression connotes a person pointed out by name or other personal description in contradistinction to one whose identity is to be ascertained by the office which he holds. Thus, a judge or a presiding officer of a tribunal are not persona designata. Perjury. Perjury is an offense of giving false evidence. If a person lawfully swears a witness, makes a statement material in a judicial proceeding which he knows to be false or which he does not believe to be true, he is said to be guilty of perjury. A person to the guilt of perjury should have a legal obligation to state the truth, and he makes a false statement knowing it to be false. Plaintiff. He is a complaining party in a litigation, commencing a lawsuit for a relief against his grievance. A plaint is a statement of facts giving the cause of action to seek a relief in the court of law. The person making and signing such a statement of facts to advance his case for obtaining that relief from the court is called plaintiff. The other person against whom such relief is sought for is called defendant. Preemption. It is the right of a person to purchase a property in preference to other. It is also the right of a person who has option of first refusal. The right is called preemptive right. The benefit as well as the burden of the right of preemption runs with the property concerned. If a society owns certain lands and desires to sell those lands, its members may be given the preemptive right to purchase those lands in preference to outsiders, non-members. Prescription. Its legal meaning is different from its ordinary meaning. In law, the term prescription indicates authorization of a right by long usage. Rights acquired by long usage of a property are known as rights by prescription. So, title by prescription is acquired by a long, continuous and uninterrupted possession of property. A prescription may be either I negative or 2 positive. Presumption. A presumption is an inference as to a matter of fact which a judge draws, or directs a jury to draw, as a matter of law. Presumptions are aids to reasoning and argumentation, which assume the truth of certain matters for the purpose of some inquiry. They may be grounded on general experience or probability of any kind, or merely on policy and convenience. Presumption may be either I. Presumption of fact, or 2. Presumption of law, or 3. Mixed presumption of law and fact. Privity. This term indicates participation in interest or knowledge. The relationship subsisting between the parties to an agreement, where there is mutuality of minds, is often indicated by this term, privity. The privity that exists between a landlord and a tenant, between a covenanter and a covenantee, is termed as privity of estate. Privity exists between any two persons when they understand each other in relation to an agreement or an estate. Promissory note. It is an instrument creating a right in the promise to demand certain sum of money agreed upon by the promisor, who has a liability to pay that sum of money to the promisee. It is a kind of a negotiable instrument. It contains an unconditional undertaking by the promisor to pay certain sum of money to the promisee thereof, on a demand made by him. Proof. Proof consists of either evidence or testimony serving the purpose of convincing the mind of the truth or falsehood of a fact. Once any evidence stands the test of severe legal scrutiny, that evidence is the legal proof. Such a proof may be either by documentary evidence or by oral evidence. Mere allegation of facts is not proof. Their evidence is proof. If there is no evidence, there cannot be any proof. Quid pro quo. That for that, or what for what, is the literal meaning of this term. This term often signifies the mutual consideration and performance of both parties to an agreement. If A agrees to sell his car to B at a price of 50,000 rupees, and B agrees to purchase it at that price, the promise of A to sell the car, and the reciprocal promise of B to buy it at that price, are quid pro quo promises. B's money is quid pro quo for A's car. Receiver. It simply means one who receives. But in legal parlance, a receiver is a person appointed by an interlocutory order of a court to receive rents or other income of an estate of which there is or are disputes between the parties to a suit. If there is a dispute as to whom the rents or other income from the properties concerned in the suit, the court may direct a person, who is either of the parties to the suit, to act as receiver to collect the rents or to realize other income. Redemption. Redemption is the fact of getting back a thing. In legal parlance, it denotes the right of a mortgager to get back his mortgaged property from the mortgagee on payment of the loan received by the mortgager from the mortgagee. A suit by a mortgager to enforce his right to pay off the mortgage amount with interest, and to get back the mortgage property discharged from debt, is known as a redemption suit. Remand. Technically, it means custody. To remand a prisoner or arrested person means to keep him in custody. This term is used in court procedure also. If any case is sent back by the appellate court to the lower court for taking further evidence, or for any other purpose which the lower court has omitted to do, the case is said to have been remanded. Remedy. It is a legal solution for an invasion of a right. Remedies may be found out by the parties themselves without going to court of law, or the matter may be taken to the court of law by means of a suit. For the infringement of every right, there is a remedy. It may be recalled that there is a legal maxim, ubi jus ibi remedium. Where there is a right, there is a remedy. Rent. The term rent in its wider sense means any payment made for the use of land or building, and thus includes the payment by a licensee in respect of the use and occupation of any land or building. In its narrower sense, it means payment made by tenant to landlord for property demised to him. Any consideration rendered by a lessee to his lessor is called rent. 78. Residential judicata. This term means matter already decided. If any matter or dispute is between any two or more parties has already been decided by a competent court, that matter cannot be again raised before the court by any of those parties. But the decision of the former court must be final and conclusive, and must have been arrived at by that court judicially. Settlement. Settlement means any testamentary disposition in writing of movable or immovable properties made, a. in consideration of marriage, b. for the purpose of distributing the properties among the members of a family, c. for the purpose of making some provision to some person who has some relationship, sapenda or non-sapenda, or for any religious or charitable purpose. It is also denoted by another term, gift. Settlement is made in favor of persons related to the settler, but gift is made even in favor of person not related to the donor. In both the cases, there is no money consideration. Sine die, it means, indefinitely, literal meaning is, without a day. This term is popularly used whenever a legislative body, such as Parliament or Assembly, is adjourned without fixing a date for assembling again. Such an adjournment is an adjournment sine die. 81. Specific performance. This term simply means performing a specific act. If any particular act, obligation, or promise is contemplated in a contract, the performance of that specific thing is known as specific performance. It is a kind of remedy available to the innocent or aggrieved party from the defaulting or breaching party to a contract. Specific performance is a specific relief specified in a contract. Stamp duty. It is a duty imposed on certain documents while being executed or registered. Such duties, taxes or levies, are imposed upon written instruments such as receipts, conveyances, certificates, and testimonies. Such duties may be either proportionate to the value of the subject matter or fixed in amount. Payment of stamp duty is one of the legal formalities to be fulfilled to validate an agreement incorporated in writing. Stay of execution. If a civil court passes a decree against a defendant in a suit, he is legally obliged to act according to the decree. Where he is unwilling to act according to the decree, or where he has failed to so act, or where he has refused to so act, or where he is delaying the act, the decree holder, plaintiff, may approach the court again for executing that decree through the court. Under such circumstances, if the court is convinced that some more time may be given to the judgment debtor, the court may order the stay of execution of the decree for the desired time. Stay of execution, in this connection, means suspension of the operation of the decree. Summons. It is a process of a court directing a person to appear before the court. It may be issued by a judge of a civil court, or by a magistrate of a criminal court. It is a call of authority to appear before a judicial officer. Surety. A person who gives security for another is known as surety. He is otherwise called guarantor. A surety discharges the liability of a debtor in case of his default. A surety undertakes to make good the loss suffered by the creditor, by the conduct of the debtor. The debtor in such cases is usually termed as principal debtor, which term further connotes that the surety is a secondary debtor.